I'm Ben Meiselas from the MeidasTouch Network. The Biden administration, through the Department of Justice, has filed an emergency motion for a stay of the enforcement of a federal court ruling in the Northern District of Texas. The Fifth Circuit Court of Appeals oversees Texas federal courts, where a Texas federal court judge who was appointed by Donald Trump, Judge Mark Pittman, ruled that the student debt cancellation program that Biden was about to implement was unconstitutional, and Judge Pittman blocked the implementation of the student debt cancellation program. In Judge Pittman's order, he stated that it was an unconstitutional overreach of the executive branch for the Biden administration to implement the student debt cancellation program, and he found that the enabling statute looked to by the Biden administration, the 2003 HEROES Act, related only to military emergencies, even though the statute doesn't say that. The statute says, or other emergencies, and other emergency situations are emergencies that could be deemed as such by the President of the United States. So the ruling by Judge Pittman is completely without merit. Now, the Department of Justice goes to the Fifth Circuit Court of Appeals to try to block the implementation of Judge Pittman's order, which would just block the implementation of the student debt cancellation program. It's going to be tough in front of the Fifth Circuit Court of Appeals because the Fifth Circuit Court of Appeals has mostly right-wing MAGA judges. But there is a chance here because Judge Pittman's reasoning was just so poorly done with respect to specifically the standing argument and what Judge Pittman ruled in this case. So the case that was before Judge Pittman that ultimately led to the blocking of the student debt cancellation program was, believe it or not, brought by two students. One student who had commercial loans and thus didn't get the benefit of student debt cancellation, and another student who would only get $10,000 of student debt canceled and not the full $20,000 if he had Pell Grants. So these individuals sued, saying they were not given the accurate procedural rights to challenge the implementation of the student debt cancellation program, and now they're going to be injured because they did not get a benefit and others are getting that benefit. And so in essence, it would be like arguing when the government bails out billionaires for us to argue, well, I'm not getting the bailout, so I've been injured because I'm not receiving that benefit. That's never been a basis for standing before. Now, in this emergency motion for stay that's filed by the Department of Justice before the Fifth Circuit, they also mention that they will be filing an appeal with the United States Supreme Court in connection with another case that blocked the student debt cancellation program. This is a case brought by Republican-led states, including Nebraska, Missouri, and several others. Those states initially filed their case in the District Court of Missouri, in the Eastern District of Missouri. There, the district judge, actually a George W. Bush appointee, found that the states did not have standing. The states then filed an emergency application with the Eighth Circuit Court of Appeals and requested an injunction blocking the implementation of the student debt cancellation program. And very recently, the Eighth Circuit granted that injunction pending an overall appeal of the district court's ruling, but blocking the student debt cancellation program. That case was also, or that ruling rather, by the Eighth Circuit Court of Appeals was also very poorly reasoned and completely without merit there as well. And there, the Eighth Circuit Court of Appeals didn't even analyze the HEROES Act or made no analysis about whether the states would actually have a probability of success on the merits. The Eighth Circuit Court of Appeals addressed one state's claim, Missouri, that because this related entity that engages in student debt collection activity may collect less student debt as a result of student debt cancellation, that the state of Missouri could possibly have standing. And then as a result, the Eighth Circuit said, because these issues here will so profoundly affect the economy, and these are important big questions that need to be resolved, we're just going to grant the injunction. There was no actual finding there that there would be a probability of success on the merits by the states, or that the Biden administration engaged in improper conduct. No, the Eighth Circuit just said, well, these issues seem complicated. Like, I'm not making this up. The Eighth Circuit just said, the issues are really complicated and they affect a big aspect of our economy. So therefore, we're going to grant an injunction. So we got two things going on right now, right? We have the Eighth Circuit Court of Appeals that has blocked the student debt cancellation program by issuing an injunction, an indefinite injunction, while this case now in the Eighth Circuit works its way through the appeals process, and that could take a year or potentially longer. And there, the Department of Justice is going to appeal to the Supreme Court, because that's where you bring appeals. The problem there is the supervising Supreme Court justice who hears emergency applications from the Eighth Circuit Court of Appeals is Justice Brett Kavanaugh. So I do not feel confident that the Supreme Court is going to grant any emergency relief filed by the Biden administration, given that it's Brett Kavanaugh who's the supervising judge. And even if Brett Kavanaugh then refers it to the full panel of Supreme Court justices, the Supreme Court justices in rulings in their last term, like a ruling involving the Environmental Protection Agency, has severely limited the ability of the Biden administration to implement agency action. So I don't feel confident that this Supreme Court is going to in any way stop the Eighth Circuit's injunction or find in favor of the Biden administration on the merits. The issue is, will the Biden administration prevail on the standing argument there, where the states are basically arguing that they would like to tax the student debt being canceled as income, and they're being deprived of that income now that the student debt cannot be taxed the way the states want to tax them, and that these state collection agencies that aren't actually state actors but are like affiliated with the states, that they're not able to collect the student debt the same way that they were. So that's what the states argue, which is a very lame standing argument. And then you go south to Texas and you talk about there the standing argument of these students. And are these real students? I mean, I'm sure they are, but they're all these groups that are filing these lawsuits to block the student debt cancellation program are proxies for the Federalist Society, who have flooded the courts with all of these lawsuits to try to find judges, Federalist Society Republican judges, who would agree to try to block this. And you go, why would they want to block it? Because their whole worldview is that billionaires and decamillionaires should get the benefits, and that everybody else, they believe that's like a handout and the government's just giving people money. But when it comes to billionaires, that's not an issue. But when it comes to working people, when it comes to people earning less than $125,000, that's where the Federalist Society says, absolutely not. We want no government involvement in that. That is completely unconstitutional. That's essentially what they're arguing there. But here in the Northern District of Texas case, the argument of the injury was that these students are saying, I didn't get the benefit, or I only got $10,000 and I want the $20,000, which is the most absurd type of standing because they haven't been injured. Their status quo remains the status quo. When the billionaires get bailed out, I still am Ben Meiselas. I didn't get hurt by that. I didn't get benefited by that. And I can't sue and say, you owe me the billionaire benefits. I guess we should now. We should all file those lawsuits. But there really isn't any standing there. So we'll see what the Fifth Circuit rules on the standing issue. But here in the motion for stay that was filed by the Department of Justice, they reference also that they will be appealing to the United States Supreme Court. So let me just read for you now also what a page from the motion for stay filed with the Fifth Circuit Court of Appeals to try to stop the enforcement of Judge Pittman's order blocking the student debt cancellation program. This is from the Biden administration, from the DOJ filing. Plaintiffs are individual borrowers who allege they were denied an opportunity to comment on the Secretary of Education's decision to provide targeted student loan debt relief to others. Plaintiffs' sole claim is that they have a procedural right to advocate for the expansion of the debt relief program so that their loans would be forgiven too, or in a more substantial amount, like the student who says, I want $20,000. The district court held that the secretary followed the required procedures, but nevertheless vacated the debt relief program after concluding that it was not authorized by statute. Thus, in response to plaintiffs' claimed desire to benefit more fully from the secretary's debt relief program, the district court voided the program entirely, ensuring that no borrower can benefit. Just think about that line. I mean, it really is beautifully written. You know, I like to geek out on these legal analysis that I do, but look what they're saying. Thus, in response to these so-called students, their claimed desire, the DOJ doesn't believe it, like it's fake, that their claimed desire that they want to benefit more from the program, now as a result, the court has entered an order that no borrower can benefit because these two students wanted more. Now nobody gets the benefit. How does that make sense? That's what they're saying in that line. And then the DOJ goes on to say the court should stay that order pending appeal. The secretary's debt relief action is lawful, and the district court's contrary holding ignores the statute's plain terms. More fundamentally, the district court lacked jurisdiction to enter an order on an unpleaded claim that does not redress plaintiffs' alleged procedural harms. In other words, plaintiffs not being harmed by any of this. What are we redressing? Plaintiffs still are not going to be able to comment by the Secretary of Education. Like, they're not getting a benefit from this lawsuit. They're not injured in any way. That's what they say right here. Plaintiffs have no greater ability to comment on the Secretary's action and advocate for broader loan forgiveness than they had before. Remember, this is what these plaintiffs are saying. They want more loan forgiveness, thus no one should get any loan forgiveness. Huh? How does that make any sense at all? A stay would leave plaintiffs in the same position and would avoid significant harm to millions of Americans who need student debt relief. The government will be filing an application with the Supreme Court to vacate a separate injunction against the Secretary of Education's action entered by the Eighth Circuit earlier this week. In light of the significant interest involved, the government respectfully requests a ruling on this motion by December 1, 2022 to allow the government to seek redress from the Supreme Court. So look, there's no both sides to this, people. You have the Democrats, the pro-democracy coalition, the Biden administration, who is fighting for the student debt cancellation program on the one hand. On the other hand, you have Republican Federalist organizations that are suing to block the program, who are going in front of Republican Federalist Society judges who are blocking the program and meanwhile allowing all of the benefits to go to the billionaires and the millionaires. That is who the Republican Federalist Society is fighting for. So I don't want to hear this both sides crap that, oh, Biden said he was going to implement it, but he didn't implement it. Yes, he did. He did implement it. He did try to implement it. He's doing everything he can possibly to implement it. And everywhere he goes to try to implement it, you get MAGA, right-wing, Federalist Society judges trying to block it and arguing that because students are not getting more of a benefit, that's how fake and phony their arguments are, that the whole program should be blocked and then nobody gets the benefit. It's utterly absurd. We are calling it out here on the MeidasTouch network, and we will continue to call it out. We are not letting this issue kind of fall to the wayside. It is critical. Hit the subscribe button. We're on our way to 1 million subscribers with your support. Please hit the subscribe button. And in addition, consider becoming a patron of the MeidasTouch network. Go to patreon.com patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's lots of exclusive content on our Patreon, but most importantly, help grow this independent media platform. We're not funded by any outside investors at all. Wherever you are in the world, you can help grow this community. That's patreon.com/MeidasTouch, patreon.com/MeidasTouch. I'm Ben Meiselas from the MeidasTouch Network.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs, It Wasn't Rigged, You're Just a Loser, at store.meidastouch.com. That's store.meidastouch.com.